Hello.
Hello.
Hi all. Thank you for coming. We're just going to give it another minute whilst we wait for anybody else that wishes to join. So I'll turn the camera off and give us a minute, and then we'll come straight back. Good afternoon, all. Thank you all. Thank you all for coming. This is the first of what we intend to be weekly webinar sessions. Myself, Peter is here, and Marie, my partner and fellow director of Woodville. Thank you all for coming. We do appreciate that some of what you will hear today, many of you will have already heard. The purpose of this first webinar is to have a recap, to discuss all things Woodville, the car finance redress scheme. There will be, as I said, weekly updates that we will be carrying out. And we felt that, well, actually, this does link into one of the questions. We will be doing the questions at the end of the session. But one of the questions that did come up was the need for weekly updates, weekly webinars. Now, this is not to suggest any problems or any issues that we have out there, but the car finance redress scheme, where we are with funding, everything that we will talk about is changing on a weekly basis, certainly in the redress scheme. Having weekly updates, we think, is important to get such developments out to all participants. So the intention for weekly updates is not just for funding, is on the car finance redress scheme, which is changing and evolving quite quickly at the moment. One other point of note that I'd like to say, we arranged this webinar early part of this week. There's a verification process to ensure that all investors, advisors are on the webinar. Apologies for some of your colleagues who might not have had that verification. Please pass those apologies on to your colleagues, and we will remedy that over the course of the coming days so that they have the access for the following week. So I think first, where we wanted to start with this update, and again, appreciating that many of you may have already, will have already had these updates through conversations that we've had or through updates that we've been distributing. The key area to start is in the car finance redress scheme, the impact that that's had on Woodville, the expectations that myself and Anne-Marie had, because ultimately a large proportion of the Woodville book is invested in car finance claims. Now, the car finance sector, the regulations, the FCA, the thematic review, court dates, fault redress scheme challenges. There's enough information in here to discuss this for the next 4 or 5 hours. So this will be a brief recap, but we feel it's important that this is a good place to start. So, as you know, investors that are here on today's webinar and advisors, we have been heavily involved in investing in the car finance claim space. It is very common knowledge that the lenders missold the consumer car finance going back to 2007. This became a claim space all in itself years ago, or a good 2 or 3 years ago, certainly through the court system. Recognizing the size of the marketplace that this claim sector was becoming, the lenders made challenges to many of the court decisions, or made challenges to the court decisions that resulted in hearings needed to be held at the High Court, ultimately the Court of Appeal, and as we know, the Supreme Court, which was not expected, which was heard in April of this year. So the impact, of course, on Woodville on this, when we looked at investing and getting involved in the car finance claim space, we recognised that the challenges may come, certainly to from the County Court, High Court, Court of Appeal. What nobody in the industry was expecting were the appeal to the High Court decisions to go through to the Supreme Court. So when we're modelling, when we're looking at a new claim type that we want to invest in, that we want client funds to invest in, we look at where the car finance claim space is. Having heard and seen the appeals come through to Supreme Court, the date of that the Supreme Court hearing March last year, that judgment did not come down until August this year. So, of course, over the whole of 2025, unexpected delays occurred. This is, of course, where funds are invested in the car finance space. And this is one of the key parts to this. The regulator recognising the Supreme Court decision, which fell in favour of the consumer, Mr. Johnson, confirming what we all knew, that the consumer had been mistreated, had been missold their car finance agreements. Recognising that this had now been official, liability had been sorted. There's no right or wrongs that needed to be decided at this point. Recognising that this was now affecting and bringing into the arena 14 million plus claimants, the regulator stepped in. As again, apologies to those that are on this call who will have heard a lot of this. The benefit is to bring everybody up to speed as to exactly where we are. So recognising this, the regulator discussed wanting to bring an official redress scheme into the space. Now, the purpose of the redress scheme was not to repeat errors that were made in the payment protection insurance scandal of years ago. This ended up being a 35 to 40 billion pound payout that the banks had to pay out, and this claim type went on for years. Keen to avoid this, the regulators stepped in and wanted to introduce a redress scheme. Now, a redress scheme designed to set out parameters to discuss the form of how the payouts will be made from lenders to the consumer, and ultimately allowing us to receive what we invested in over recent times. Now, the redress scheme, before that can just be launched, a consultation period towards the end of last year was, following the Supreme Court decision, a consultation period was entered into, which allowed the lenders and also the law firms acting for the consumer to consult on what the FCA's findings were. Now, this is not unreasonable, but 12 weeks was the period set that the FCA gave both sides of the fence time to consult on the redress scheme. Now, this takes us through to November, December of last year. We were fully expecting following the Supreme Court decision, it's set in law. There's no other higher court in the land that can validate the facts the consumer has been mistreated. From a Woodville perspective, we expected payments from lenders to their law firms, and ultimately law firms repaying us to, at the latest, have happened at the end of last year. It was not beyond the realms of possibility that we should have been paid earlier in the year, and we should have been, and we wouldn't be having these webinars or these discussions had the challenge not gone through to the Supreme Court, which again in the industry was not expected. It has happened, and we are where we are now. The consultation period took us through the back part of 2025. Once this period had finished, the time is needed for the FCA to put together their report. Ultimately, what is their redress scheme? Again, allowing time for the regulator to put all this together, a 385-page redress framework was put in place and finally launched in March of this year. Wonderful, we would all expect. Redress scheme starts, lenders understand now what the parameters of how they need to make their payments back on behalf of missold car finance claims. Again, the industry was not expecting 3 challenges to be entered from the lenders. Now, the challenges, and this is an important point that I really want to make sure is understood, the challenges that came from the lenders is not on the validity of where the right or wrong has been done. That has been set out in the Supreme Court decision. That was done, verdict handed down in August last year. The challenges to the scheme are more on the procedural elements. They are on the validity of whether the FCA can or cannot introduce rules pre their existence, which is from 2007 through to 2014. So these in the UK, rights to justice, these have to be heard. These challenges have to be heard. There is also another one from our side of the fence, from a consumer organisation, which is challenging the level of payouts that the regulator are stating is due. Those challenges have to be heard, and again, they weren't expected. such challenges having to be heard takes us past March. So whilst we're expecting payouts, certainly in April, allowing time for those challenges to be heard, again, results in more and more delays. Now, we have been working in the background on strategies, funding, which we will come on to and provide updates on those that hopefully will get Woodville back on track very, very quickly. I think on the finishing off on the FOS delays before I hand over to Anne-Marie. Whilst these delays, and this sort of forms into what we will be discussing later, and also bringing back to the need for having a weekly webinar. Again, as many of you may well all be aware, for the benefit of those that aren't, the car finance claim space is changing quickly. There was an article in Reuters magazine, well-known Reuters magazine, which suggested banks are starting to look at the feasibility of settling claims early. There's no guarantees, not stating for 1 minute there's any guarantees. However, due to the ongoing delays, due to the FCA working incredibly hard to put this framework in place, they have made a public statement that should these challenges be successful or unsuccessful and appeals to them made, the FCA could well just scrap the redress scheme. Now, again, please don't panic when you hear that the regulator could potentially scrap the redress scheme. It wouldn't change a huge amount. The claim still goes through to the lender. The lender knows they have done wrong as per the Supreme Court's decision that came down in August last year. The lenders would still have to pay out the claims that our law firms that we fund are making. One of the key differences, it may take an extra 8 weeks, may take an extra period of time for the lenders to settle. But the key is that lenders could be exposing themselves to substantial higher payouts than what would become doable under the redress scheme. So again, feeding back to the need for a weekly webinar, 2 weeks ago, or it might be 3 weeks ago now, the Reuters article came out which discussed that banks are considering now, for what reasons I've just explained, considering payouts early for the claims that they have. We know of 2 lenders who are